I will please your Lordship. Lordship, I beg to make a mention of item number 3 of the daily list, your Lordship. Your Lordship, I pray for 3 weeks' time, your Lordship. Some more time is needed
The
for...
matter was heard.
No, your Lordship. Not yet, your Lordship.
How long?
3 weeks, your Lordship.
Why?
For preparation, your Lordship.
Were you supposed to file paperwork here?
Your Lordship, we have not been directed so far, Your Lordship, but if Your Lordship requires
It's not that. Whether any order was passed in that regard.
No, Your Lordship.
Lordship.
If it's not required, then not required.
Sure.
We'll see. You're for respondent.
Number 3, your Lordship.
3 and 1. Mr. Lender counsel for the respondent number 3 has sought for audition on the ground that he is not prepared to be heard in this matter today. The prayer not be objected to by the lender counsel for the appellant. Matter is adjourned. This is after 3 weeks.
Highly obliged, your Lordship. Good day.
Supplementary list, item number 1.
Yes, Mr. Sen, what is this?
Because there is a caveat. I've already served a copy on my learned friend who's appearing for the respondent number 1. You want to take it up today?
Yes.
My lord. What is under challenge, my lord, is an order dated 1/4/2025 dismissing my application under Order 7 Rule 11, whereby I sought to have their plaint rejected. My learned friend is representing the respondent number 1, who is the plaintiff before the learned trial court, in a suit for declaration of ownership, recovery of possession, and consequential reliefs. But in that application, we entered appearance and filed an application under Order 7 Rule 11 for rejection of the plaint on the ground that it did not disclose any cause of action and that it was barred by limitation. They filed their show cause. The learned court heard the matter and dismissed my application. Against that, we preferred a revision application, my lord.
It is not an appealable order.
No, my lord. It is not an appealable order.
You are
I'm for the respondent number 1, my lord.
you have filed the
My lord, we filed the suit, and if we make file the counter,
you have filed a caveat.
we file the caveat, my lord. Yes, but if your lordship would grant us 1 week to file a counter.
Counter. Where is the scope filing counter?
No real scope, my lord. I think on the records, it should be sufficient. They can argue on the basis of their application. In any case, they have to argue within the parameters of the plaint itself.
You have to take steps for the other respondents.
Other respondents.
Heard Mr. Easton, learned counsel for the petitioner. Learned G appearing for you are clear as G.
My lord.
Learned G appearing for the petitioner. Also heard Mr. Learned counsel for the respondent number 1, who has entered appearance on behalf of such respondent and has also submitted that a caveat in this regard has been referred. The caveat is accordingly discharged. Mr. Sen has further submitted that he may be allowed, that the petitioner may be allowed to take steps for issuance of notice on the other respondents. Pray aloud. Let notice be issued, the same returnable within 2 weeks.
Lordship. So I'm also praying for an interim order staying the trial of the case, my lord, because this matter relates to an application under Order 7, Rule 11. Now, in any case, my lords, I'll be otherwise directed to file my written statement.
What is the stage? Here, you see, the stage was for, at the initial
Yes, my
stage
lords. As soon as the suit was filed.
Only the plain has been filed.
Yes.
The statement filed.
No.
Oh, no, but you have, okay.
No, they filed this suit on the 21st
now
of
what
December.
happened is the court will give direction for written statement to be filed.
Yes, my lord.
So,
But if it is barred by limitation, usually what happens in these cases, once an application under 711 is filed, it is a direction of the Honorable Supreme Court that the trial should be stayed and the 711 application should be disposed of at the earliest, without any further directions for filing of a written statement. That is the only reason why.
you have you have that authority?
Yes, my lord. In fact, the learned trial court had also kept the suit in abeyance after the 711 application was filed.
Oh,
Kindly see
then
paragraph.
it has kept the.
No, it had. So as soon as this application was dismissed, the entire proceedings have been revived. Kindly see paragraph 5, my lord, in the second page.
Yes.
Once an application is filed under Order 7, Rule 11, the court has to dispose of the same before proceeding with the trial. There is no point or sense in proceeding with the trial of the case in case the plaint is only to be rejected at the threshold. Therefore, the defendant is entitled to file the application for rejection before filing his written statement. In case the application is rejected, the defendant is entitled to file his written statement thereafter. But once an application for rejection is filed, the court has to dispose of the same before proceeding with the trial.
Well, this is with regard to proceedings before the trial court.
Yes, my
Yes, my lord.
I would
My
say
lord,
that
if I
this
may
would have to
submit-
be treated as a continuation
No,
because
not
I'm filing a
not
revision
necessarily.
challenging the order itself. Well, it's on the face of it, the order, well, it suffers from very serious defects. I can take your lordship just to the impugned order, just to prima facie satisfy my lords that there is no reasoning assigned by the learned trial court.
No, but you see, Mr. Sen,
My lord,
be that as it may,
lordship.
the
My lord,
response
if I-
has to be heard.
No, I have no difficulty with that. I'm only praying that the
even on-
trial be stayed to the extent that I'm directed to file my written statement, my lord. That's all.
That you can always make a prayer before the trial
The
court.
trial court may not agree, my lord, because merely because a revision application is pending before this court, the trial court may not agree to stay the proceedings. My lords will kindly see, when this application was filed before the trial court, this was the order that was passed. And this was passed in the main suit. Order dated 14/6/24.
Yes.
Kindly see the third last line. WS in the incident case is kept in abeyance after disposal of miscase number 27H of 24. This is the miscase under Order 7 Rule 11. Now this came to be rejected. So now the entire proceedings is revived. I am to file my written statement.
When is the next date fixed?
17th of this month, my lord.
17.
17th. Sorry, 17th of next month.
May it please your lordship, if I may object to my learned friend's submissions. The fact of the matter is that the application under Order 7 Rule 11 was filed in the learned trial court in April of last year. It took a year for this matter to proceed to actual final hearing and disposal by the lower court. And during that time, as my learned friend said, the matter was stayed. There was a stay on the matter. Now the matter has resumed its natural course. My learned friend has been directed to file his written statements. My lord, as far as the judgment that my learned friend has brought to your notice, that is in respect of proceedings in the trial court. The fact is, if a stay is granted here, we don't know how much further, beyond the 1 year that it took in the trial court, we don't know how much further it might take. If my lord may just let the proceedings in the lower court proceed, while my lord may take up this matter as early as convenient with this
See,
court.
the fact remains that if we allow the matter to proceed in the trial court, consequently this application becomes infructuous.
Lordship.
Because,
It is
you see,
counterproductive.
because the fact of the matter is, you see, an application has been filed wherein your claim was thought to be rejected,
Lordship.
Absolutely sure.
and that was not allowed by the trial court. So presumably the trial will continue.
Yes, my lord.
It will continue in its own course.
It would.
Filing of WS, so on and so forth. Now, against that order, the petitioner here has come before this court. So, if we allow the proceedings to continue before the trial court, and simultaneously, if this matter is also taken up here, like you rightly said, it may take 1 month, 2 months, 3 months, 1 year, 2 years, we don't know.
Lordship.
In the meantime, what happened? Eventually, if that order is set aside, the impugned order is set aside, and in the meantime, the trials has proceeded to what stage? We
That's
don't
a burden on the trial court.
know. I mean, it's,
Lordship.
it doesn't sound logical.
And I'm agreeing, I understand my friend is anxious, I'm agreeing to have this matter heard at the earliest.
So that will be the endeavor of the court or the parties for that
Yes,
matter.
If my friend agrees, we can have it next week, the week
But as
after.
far as your prayer for stay is concerned, we will take it up after the notice has been issued to all the.
Yes, my lord, no problem, no difficulty.
So, today is.
May I just also point out, as far as the other defendants are concerned, they're only co-defendants in the main suit. The relief is sought against the respondent number 1 only because he's the sole plaintiff before the trial court. As far as the other defendants are concerned, they are not really concerned. They did not participate in the hearing as well.
You have read them as parties.
Yes, my lord. Lordship will recall in the other case, then an objection was raised by the respondent there that all the other parties in the original suit should also be made parties. So merely as abundant precaution have made them parties. Otherwise, for a 711 proceeding, it is only the plaintiff.
We'll see how they react.
Lordship.
They may come, they may not come.
My lord.
Mentakan tarik. Ako hindi. Ako. 1, 2, 3. You said 17th.
17th of June.
So we'll fix this matter on 5th.
5th of June, my lord. The only thing, my lord, is that the time period is continuously running. The clock is ticking as far as the written statement is filed. I have 90 days to file a written statement. My lord. That's the only reason. So Lordship will fix it on the 5th of June.
5th of June, would that suffice?
Should be sufficient, my lord.
If you see, we'll see how, what transpired on 5th. You file a separate application?
No, my lord. It's contained in the main prayer itself. So most of the other courts are also entertaining applications.
What does the rule say, sir?
To the best of my knowledge, my lord, there is no office order from this High Court which mandates the filing of a miscellaneous application.
Well, in the meantime, on the prayer of Mr. Sen for grant of an interim order, that is for stay of the proceedings before the trial court. Upon hearing the parties, this court is of the opinion that the matter will be heard in the presence of all the respondents. Accordingly, this matter on 5th June.
Grateful, Lordship.
Daily list item number 1.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mr. Conducting Counsel, Mr. K.P. Bhattacharya. Your Lordship, he is in bereavement. There is some death in the family and he has gone to Guwahati today morning. So I am praying for 1 week time may be granted for filing of written argument, Your Lordship.
Who's for the...
No objection. I am
Your file?
for the petitioner. We are ready with the written statement, Your Lordship.
Have you filed?
No, not yet, Your Lordship.
Do it. Who else is there?
Your Lordship, here is formal party with correspondent right Ministry of Human Resources.
Mr. Learned Counsel for the petitioner has submitted that the brief written submission on behalf of the petitioner has been filed. However, Ms. S. Study Learned J has sought for accommodation as far as the state respondent is concerned on the ground that the Learned Conducting Counsel is not in station due to bereavement in the family. Mr. Learned Counsel appears for the respondent. Respondent number 5. On Premier, list this matter on 28th.
Your Lordship.
Much obliged, Your Lordship.
Item number 2.
Yes.
Please, Your Lordship. Lordship, appeal is otherwise ready for hearing. If Lordship chooses, we can take it up.
May I please, Your Lordship? Actually, I was out of station, Your Lordship. I could not prepare, so I'm seeking 2 weeks' time, please. Next date possible that do.
Mr. General will start.
I'm not ready, Your Lordship. Please, 2 weeks' time.
Not ready, yes, I understand.
Yes.
So the court will not force you. But Mr. General is ever prepared. So what do we do?
No, I'm totally not prepared, my lord. Please. 2 weeks only, Your Lordship.
Yes, Mr. General.
Well, if he wants time.
Mr. Rai Chaudhary, learned counsel for the respondent 1 has sought for accommodation for the day on the ground that he is not prepared to be heard in this matter. Mr. S. Jindal, learned counsel for the appellant, has no objection to the premier. We'll have it on 28th then.
2 weeks' time, Your Lordship.
Why 2 weeks? You don't need that much time.
First week of June, Your Lordship.
On 30th, that's Friday. On premier parties. 30th, no. Not on 30th. Die aardleiter ik dan ook nog. Sa. 4th. 4th. Noem toch as 4th. For this is hearing column, isn't it?
Yeah. Obliged.